properly now. So welcome. So this is the our third iteration. So we're getting there, slowly but steadily. And having discussed in previous seminars the framework under the Refugee Convention, the rationales for the convention, the definition of a refugee, some of the interpretive challenges. Um, Today's a bit of a reality check in the sense that what we're going to be discussing is essentially ways in which states seek to evade the responsibility to having to address protection needs of refugees, having not or not finding themselves in a position where they need to provide protection, and so this doesn't mean that all that we've discussed has no meaning. Of course, it does. And of course, states don't always succeed in that. And of course, not all states engage in this all the time. But it is an important feature, this almost cat and mouse game between um, asylum seekers trying to get somewhere and different states in different guises trying to find ways for them not to be able to do so. And where the legal frameworks around this are evolving. And they're evolving as practices change, but they're also evolving as our understanding of concepts such as jurisdiction change. So this all will become, I hope, much clearer as we go through the analysis. So as usual, going to try and have you see this. Though my computer is being very slow, but hopefully, I'll give it one more minute. Hopefully, you can now see the slides, or the slide, I should say. Um, for this seminar, which would deal with non-reforma, with access to protection and notions of externalization. So this is what I want us to discuss today. So we're going to start off by talking about this very core principle in international refugee law of non-reform. And I say in international refugee law because this is where the origins of the principle lies. The principle applies in other international regimes as well. I've written about its application in international humanitarian law. In certain contexts, it applies in certain other contexts in international human rights law, and at least a form of that principle is now deemed to be customary international law, which means that it applies even in relation to states that haven't signed up to the Refugee Convention. But the challenge of the non-refoulement principle in international refugee law is that, firstly, it is itself non-absolute, and secondly, that it only kicks in when a state is having jurisdiction over a person. Now, jurisdiction doesn't necessarily have to mean physical presence, right? So that's the first thing we want to unpack. It's the most classic form of jurisdiction over a person is when they are within your physical territory. But there are other situations short of that that would still amount to jurisdiction, but it's in that terrain that much of our discussion would arise, right? And that's why I build under the second heading for today as reformer challenges. And in a way, I go from the least controversial to the most controversial in terms of state practices, or perhaps the least defensible to the more defensible. So I'm going to start by talking about rejection at the physical border, then talk about interdiction at sea, so situations or interception, as it's sometimes referred to, on the high seas, and then talk about the policies around visas and ports of departure. So essentially, the most effective way in which states prevent someone from a country uh, that generates asylum seekers, that prevents that person from getting to its territory, which is to simply not allow them to board a plane or a ship or a train. And the easiest way to do this is to get the airline or the shipping company or the train company to become immigration officers, right? And to check whether you have the correct visa. And the easy way for the state to make sure you don't have the correct visa is not to issue a visa, right? And so we will talk in this context about the inverse relations that I argue rather exists between how how many people or what likelihood there is that people from a certain state would need protection somewhere else and their ability to legally travel to that state in order to receive protection, right? That's a built-in inverse relations in the way the global system works today. The most classic example that I like to give here is the distinction between Singapore and Eritrea, right? The Singaporean passport is arguably the most lucrative or best passport in the world in terms of the number of countries one can travel to either visa free or with receiving visa on arrival, which means you've already arrived in another state and you are within its jurisdiction. That's 192 countries. The other side of the chart occupies places like Eritrea, where the number is 38, right? And most of those countries are in the global south. You'll be pleased to hear Israel is much closer to the 192 than to the 38, but it's not quite there, and the reasons are probably less likely to do with the flight risk or something, or the chances that Israelis would seek asylum, because the sort of countries that um, do not allow Israelis to enter visa-free on arrival are not the countries that operate these regimes that I'm going to be discussing later. So there's this inverse relations, right? Which I want to unpack, and I want to talk also about this concept of indirect reforma. So the notion that reforma doesn't just pertain to the state itself engaging in the practice of putting somebody back on a boat and returning them to their port of entry where they fear persecution, uh, but rather the state using some intermediaries, and that's a direct link then to the last bit of today's discussion, which would deal with externalization. So the practice of the state undertaking in other places or having it undertaken in other places activities or actions or processes that ordinarily you would expect the state to undertake in its own territory in relation to asylum seekers. And that can go from just processing the application to the whole taking of responsibility for asylum seekers. We'll discuss whether that's compatible with the Refugee Convention and whether different practices, pushbacks, pullbacks, or containment practices, and others are ones that sit comfortably with the refugee framework, whether they have now become the rule rather than the exception. That's part of that kind of reality check that I suggested we're going to be engaging in today. So that's the plan. I don't quite exactly know how long it will take us. We will see if we finish the materials for today early. We might get started on exclusion. So we'll play it by ear. Any questions on this framework for today? What I mean by the various terms. I mean, obviously, things will hopefully clear out as we proceed. Okay, I don't see any hands, so I will assume we're all good for now, and I'll just kick off. So let's talk about the principle. So what is non-reformer? So the principle is very clear. It says no contracting state, right? So no state that has signed the Refugee Convention shall expel or return, and in French, refoul, and we'll come back to that idea of refoulement actually being the term the convention itself uses. So the English text of the convention has the provision related to non-refoulement. Um, in French, right? Which is so not the whole provision, but the term itself. And that is because the translation in English isn't quite there. So expel or return doesn't fully capture the notion of refoulement, and so we'll try and unpack that. So no contracting state shall expel or return a refugee in any manner whatsoever, right? I've emphasized us to the frontiers of territories where his life or freedom would be threatened on account of one of the five grounds in the Refugee Convention. Right? So, what's the first thing that you notice about this provision? What, what is the scope of the obligation? Which states does the obligation pertain to? Fairly straightforward question. Yeah.
Maybe the states that are side to the convention and just maybe I didn't understand right the question. Can you just reframe it?
Yeah, sure, of course.
Thank you.
What I'm saying is you're a state of asylum, right?
Mhm.
You've got somebody who's arrived, let's say arrived, but for the sake of the ease of argument, which are the places you can't send that person to if there's a threat to their lives? Well, what types of places are there?
Oh, like countries that are not like respecting the race, the religion, like um the reason the man came to my country is the reason that I can't ignore and I can't send him back to his death.
Sure. So that's the reason why you can't send them back, right? But the key thing which was implicit in what you said is that this provision doesn't limit the application of the principle or the obligation to the state from which that person came, right? So if the provision had said no contracting state shall expel or return a refugee in any manner whatsoever to their country, if in that country their life or freedom would be threatened, right? So that's not what the provision says. It says explicitly to the frontiers of territories. So to anywhere, right? So in other words, if you've got somebody from Eritrea who comes in and he's threatening Eritrea, and you want to send them to Libya, and in Libya they would be threatened, right? That would be equally a breach of Article 33, right? So that's the first kind of, I think, critical thing to understand about non-refoulement, and that's why this notion of indirect refoulement is also significant, right? Refoulement doesn't extend only to the place from which the person arrived. It extends anywhere where they might be a threat to that person. Of course, um, the complication arises where the place you are sending that person to isn't a place where they're threatened, but you are unsure whether that place has a proper asylum process that would ultimately ensure they won't get sent back to their country of origin, right? That's the core of debates of the nature that existed, for instance, around the Israeli policies um, of um, uh, of having transfer agreements with Rwanda and Uganda. It wasn't so much that there was a risk to people in Rwanda and Uganda themselves, but that Rwanda and Uganda would not provide them the sort of protection they required, and they would end up ultimately having to return to their country of origin or to continue their travel, right? So I will come back to the Rwanda-Uganda example later, actually, in the context of the UK policies, because there was a bit of um, a cross reference when the UK was trying to put in place an agreement with Rwanda to the Israeli agreement, and I think Shacha will also discuss some of these elements next week. So that's the first thing about non-refoulement, right? So non-refoulement in the Refugee Convention um, is is wider ranging, but at the same time, non-refoulement in the Refugee Convention is not absolute. What do I mean by saying it's not absolute? It means that there are certain people whom the Refugee Convention, and I repeat that point because we will see in a few minutes that permission to refoul may be qualified or may be outdone by other obligations the states have. But under the refugee conventions, there are certain people in certain circumstances that you are allowed to send back essentially to danger, right? To a situation where their life or freedom would be threatened. And those are people who threaten you, right? So to put it in a blunt way, right? So if a person if you have reasons to believe that that person poses a danger to the security of your own country, or if they had been convicted by a final judgment of a particularly serious crime, convicted somewhere else, right? And as a result of that conviction, you deem them to constitute a danger to the community of your country, then in those circumstances, you could, under the Refugee Convention, send them potentially back to conditions of persecution, right? So the Refugee Convention, in that sense, created a degree of compromise between the obligation not to engage in a practice that exposes somebody to persecution and the need for the state to protect itself, right? To protect itself from somebody who can be harmful to it. Now, the key point here is that, and as I said, we probably will get to exclusion tomorrow, but we might get it to it today. Exclusion from refugee status is very different because there the question is one of desert, right? Do you deserve to get protection? And you might not deserve to get protection under the convention because of something you have done in the past, right? So there the focus is on things that you've done in the past that disqualify you. Here, like the refugee definition itself, this is a forward-looking perspective, right? So the perspective, in the same way the Refugee Convention being forward-looking, asks the question, what will happen to this person if I send them back? At the same time, the Refugee Convention asked the question, what will happen to us, as you were? What will happen to the country if that person remains, right? And so in certain circumstances, rather unusual, exceptional circumstances, the state may say, we are not willing to take that risk. And the convention actually permits that position to be taken. Um, so if we only had the Refugee Convention to address questions of reforma, there would be circumstances where reforma would be possible, right? So that's the starting point. Now, the reason this is not the end point, but the starting point is, of course, that other international instruments take a different view to the reforma obligation. And prime amongst those, perhaps, is the Convention Against Torture. And the Convention Against Torture, of course, applies only in limited circumstances, so only when someone would be subject to torture, as defined in the Convention. But that treaty says no state party shall expel, return, refouler, or extradite any person to another state where there are substantive grounds for believing that they would be in danger of being subjected to torture. And there is no second provision or second or subparagraph that says, but if that person poses a danger, then you can send them to be tortured, right? So the obligation is an absolute one in those circumstances. And so if you've got a state that has someone who would meet the refugee definition and also, because the overlap exists, of course, it's not a full overlap. Somebody may be subjected to torture not for a convention reason, and somebody may get refugee status and not be subjected to torture, right? So the two are not identical definitions. But if you've got somebody who meets both, then of course the stronger or stricter obligation applies. So in those circumstances, somebody who would be subjected to torture would not be returnable or refilable, even if they pose a danger to your country. And this is not an entirely theoretical question or legal question. There was a specific case in Canada some time ago called the Suresh case, related to somebody who was fighting for the Tamil Tigers, so-called, so the um, an armed group that operated in Sri Lanka against the government, and they were deemed to be dangerous potentially to Canada or to people in Canada. And the Canadian government said, we acknowledge that if we return them to Sri Lanka, they might face danger from the Sri Lankan government. So all else equal, they would be refugees, but we don't want to take that risk with allowing this person in, and we are permitted in Article 33(2) to not apply a non-refoulement to them. And the Canadian court said Article 33 of the convention, which on its face does not categorically prevent deportation to torture, or reject deportation to torture rather, should not be used to deny rights that other international legal instruments make available to everyone. International law generally rejects deportation to torture even when national security interests are at stake. Fundamentally, it's to say to the Canadian state, you've got somebody in your jurisdiction, you can't send that person to be tortured. If that person poses a threat to you, then there are other things you can do. Of course, as we know, there are security measures you can take. There can be preventative detention or surveillance or tagging or what have you. But what you can't do is send them back to be tortured, right? And that's and that applies also in other international human rights instruments. So the Covenant on Civil and Political Rights, which I think I've mentioned yesterday or the day before, which generally protects a whole slew of rights in that sphere of civil and political rights, has specific provisions around the right to life and the prohibition on torture or inhuman or degrading treatment or punishment. And in relation to those types of provisions, they have been interpreted to mean a non-reform obligation that is absolute, because those rights are deemed to be absolute and not subject to a proportionality or limitations analysis, right? And so that's the kind of the framework under which our discussion proceeds is one where there will be some circumstances, perhaps, when people who would be refugees under the convention are still returnable, but they're fairly rare because the likelihood is that in those circumstances, refouling them would also breach one of the other obligations that the same states have under human rights treaties. And given that virtually all countries that signed the Refugee Convention have also signed the Convention Against Torture, the Covenant on Economic, Social, and Cultural Rights, of Civil and Political Rights, the Convention on the Elimination of Racial Discrimination, Convention on the Right of the Child, and others, then it's very unlikely that there will be a case where somebody who is deemed to be under that risk would fall through the cracks, right? Which is a different way of saying that in today's kind of context, Article 33(2) has broadly become disused, right? Or the legal kind of technical term is that it's fallen into desuetude. That's the kind of technical jargon term. So it's not being applicable or can't be applicable. And that was very different in 1951, right? Because in 1951, when the convention was drafted, none of those other treaties existed. And so the drafters clearly thought that there would be circumstances where states shouldn't be forced to take a risk. But subsequently, the development in human rights law has changed that balancing act, I suppose, for want of a better word. Does that make sense? I know in a way that kind of took you a little bit deeper into the relations between different international treaties and that. And I know most of you haven't studied international law, so um, if this wasn't clear in any way, then do stop me. But um, I'm not seeing anyone jumping, so I will hope and assume that's fine. Um, so let's then, with that in mind, let's assume for the sake of our discussion, reforma applies, right? If there is jurisdiction, we move to the kind of next big question, right? Which is when do states have jurisdiction over a specific individual? And the most obvious cases are when somebody's in their physical territory or in their territorial waters, right? So if somebody's in your territorial waters, it's akin to being in your physical territory. Somebody in your airspace is also in your territory, right? Somebody at an airport, that's the most common kind of, misnomer that people think that because they haven't yet gone through passport control, they're not somehow in the country. That's of course false, right? You enter the country when you enter its territorial waters or airspace or land. That those are uncontroversial statements, right? And so, in those circumstances, somebody is already within the jurisdiction of the state. But what happens at the actual physical border, right? So there's no such situation uh, in in the sea, right? Or theoretically there could be if you had a line of ships just lining up your nautical mile designation, right? So the point at which your territorial waters end, you could say that would constitute a form of a physical border in the middle of the sea. But normally speaking, in the sea, you move from international waters to territorial waters in a way that's quite uninterrupted, and often there aren't even any international waters, right? So you think about the situation between the UK and France, the channel between the two countries. You are either in French territorial waters or you're in British territorial waters. There's nothing in the middle. It's not wide enough, at least in the area where people cross, for there to be international waters. But with a physical border, the situation is different. Think about the border between Israel and Egypt or Israel and Lebanon. Um, there is a physical border. Somebody may come to the border. They may be at the border itself, but not on your side, as you were. They are on the other side. And the question is, they come to that border, right? And let's assume, to kind of make the case, more solid, they don't come to an area in the border where there's just a fence and there is no discernible crossing point. They come to a crossing point. So they come to a place where other people are able to cross if they have visas or otherwise, and they say at that border crossing, we have an asylum claim, we want to lodge it. We can't do it from within country. We have to enter. If you don't let us enter, we will be subject to persecution ultimately. What happens then? So the position the UNHCR has taken, as dating as far back as to 1981, is that the principle of non-refoulement includes non-rejection at the frontier. And and that idea is supported firstly textually by the other regional treaties. So I mentioned in the first lecture that following the 51 Convention, some of the regions in the world adopted an expansive refugee definition. But more importantly, for this context, they also clarified or elaborated the understanding of what reforma means. So prime amongst those is the convention of now the African Union in Africa, where Article 7.3 of that convention says no person shall be subjected by a member state to measures such as rejection at the frontier, return or expulsion, which would compel them to return or remain in a territory where their life, physical integrity, or liberty were threatened for the reasons, and this then harks back to the reasons under the convention for getting refugee status, right? So the convention here spells out that non-refoulement, which is the title of the provision, includes amongst its manifestations the rejection at the frontier. So if you have a border crossing and you have people approaching the border and you tell them you have to turn back if you have an asylum claim, that amounts to rejection at the border. If that person had their claim been assessed, been found to be a refugee, then that would constitute reforma. Yes, Avia.
So you'd said beforehand that this isn't as relevant for the sea,
Hmm.
but because there supposedly aren't physical borders, but I could be wrong, but I recall cases where refugee boats were met outside of a country's territorial water in the middle of the sea by officials who did turn them away. Would that not still constitute a rejection? Like, does that not answer that criteria?
Absolutely. So we will come. We will.
Okay.
That you are absolutely right. Right, and those are that's I when I set out the sequence in which I want to discuss cases, I said I'm going to start from the least defensible to the more defensible, and at least states thought was defensible, which was exactly the practice that you describe of interception or interdiction in international waters, so outside your territorial waters. That's something you can't do with a physical border on land, right? Because you can't really go into a neighboring state's territory to prevent people from coming in, but you can try and do in international waters. It's precisely what some states have done. And I don't want to preempt our discussion. We will see that there have been different judgments as to whether that practice constitutes reformer ultimately, whether that practice of intercepting a boat on the open sea and then essentially forcing it to turn back to its place of origin without entering your territorial waters, but doing so with physical or coercive force, whether that constitutes reformer. We will see that there were different positions. I mean, there is, in my view, a correct position, but we'll come to that. But your instinct is correct. I suppose my point was to say that with a physical land border, um, where one state ends, the other state begins, right? And that is different on the open sea, where at least in some places, as I say, the English Channel or the Channel is different because there's no international waters, but the Mediterranean has international waters, say between Libya and Italy or Malta. Um, Australia obviously is surrounded by international waters differentiate it from countries that generate asylum seekers. Similarly, the United States, which was the subject of one of the cases, has international waters between it and Cuba and Haiti and others, right? So but your instinct is right, right? That's where the bigger challenge rises. But the interesting thing about the rejection at the border point is that the position in international law seems to be settled, right? So there have been several cases. I don't know why I haven't included it in the slide, but it's on the reading list. Um, most most recently, a case called NDNNT in the European Court of Human Rights, where it was made very clear the rejection at the border could constitute reforma if, of course, the conditions for reforma apply, which means concretely that if you reject people without giving them a chance to initially at least make a claim and without you having an initial assessment of whether there might be a basis for the claim, that implies reforma. But the fact that the international law is settled on this doesn't mean the practice doesn't exist, right? So I often give the example, and it's very fresh in your minds from yesterday that we've discussed the policies around Ukrainians being and others from Ukraine being able to enter the European Union after the full-scale Russian invasion and get protection. But just a few months before that full-scale invasion in the autumn of 2021, there were people trying to enter the European Union, particularly trying to enter Poland from neighboring countries, particularly Ukraine and Belarus, who were not Ukrainians or Belarusians, who were people from other countries who didn't get sufficient protection or didn't think they got sufficient protection in those countries and wanted to enter the EU. and they were stopped uh, by the border police, sometimes violently, and were unable to enter. This ended up ultimately in the European courts and was found to be a breach of the obligations under the convention. So you can see this case in through two lenses. The more optimistic lens will be to say that the principle has been confirmed, right, and the breach has been found. The less optimistic scenario would be to say that ultimately for those specific individuals, they were turned back, right, and there's no way to ultimately force a country that doesn't want its border open to open it, right? There's no external force that could do this, and certainly a court couldn't do this. So, I mean, a domestic court, of course, could, but an international court or the European court um, would struggle, right? So that's the easy scenario in some ways. I say easy at the same time. There is a recent article of mine that I've referenced, I think, in the first seminar, which is open access. So I'll send the link. It's quite lengthy, but I think worth reading, at least. That assesses specifically the case of the border closures with Gaza um, after October 7th, right? Effectively hermetic border closure for Palestinians who wanted perhaps to leave the Gaza Strip, most notably with Egypt, who was not a party to the conflict, and was at the same time opening its border virtually at the same time to people fleeing Sudan and the civil war there, um, to very large numbers of Sudanese, in fact, to have entered Egypt. So that was a recent case of effective border closure. Now it wasn't the case that zero people were able to enter. There were some instances people with another nationality, people who had family links somewhere else who were able to transit via Egypt. But as a policy, if somebody had arrived at the Rafah crossing and sought to enter Egypt and seek asylum there, Egypt being a party to the Refugee Convention, or indeed use Egypt as a base to get somewhere else, they wouldn't have been able to do so, right? So in this paper that I've written, I argue that's a breach of international law, but I also show that that's quite a rare case, right? So again, the flip side in terms of if we if we move between optimism and pessimism, or between breaches of the law and upholding of the law, we look through recent cases of conflict, and we would be hard pressed to find a place where there was a conflict, and and it wasn't the case that at least one neighboring country opened its borders and allowed people to enter if they were fleeing that conflict. So um, I list in the paper the various examples, including Afghanistan, Syria, the DRC, Sudan, Myanmar, and others. Right. So this is the case of Gaza is relatively unique. In fact, even Lebanon is an interesting example where both in the autumn of 2024, in the previous round between Israel and Hezbollah, and in fact now, there have been Lebanese nationals who were able to cross into Syria and vice versa in previous instances. Um, so the principle ultimately is upheld in international law as a matter of the text of later treaties like the OAU Convention and the jurisprudence of courts, as well as the position of the UNHCR. But in state practice, on individual scales, so not in a conflict situation, it is continuously challenged. So it's challenged on the US-Mexican border, very much so. Domestic law in the United States has been you can say uh, vandalized perhaps to try and make it possible to to avoid the obligations under the Refugee Convention, which the US remains bound by under international law and under domestic law, because it has a domestic incorporation of refugee law in the Refugee Act in the US. Um, so the US is a clear example with Mexico. As I say, there are still pushbacks at various European borders in various instances. We still see Greek border guards try to push back people at the border with Bulgaria. We still see Hungarian. Maybe we won't see any more doing that at the Hungarian border. We have seen it, as I said, with Poland. We've seen it in Spain in the past, not very recent past, but several years back in its two enclaves in North Africa, Ceuta and Melilla, which are essentially Spanish enclaves in the middle of Morocco, where people were trying to scale the fences and enter those spaces and were pushed back. So it's a bit of a seesaw, right? Or the picture is a bit of a mixed picture where the principle is clear. The breaches of that principle are occurring and are occurring in not insignificant instances. Um, but that's, as I said, in response also to Avia's kind of point earlier, this is the least defensible type of evasion of jurisdiction, because it really is the case if one thinks about it um, from a what we sometimes call teleological interpretation of the convention. So if we think about what is the purpose, a purpose of interpretation, why is this convention there? What is it meant to do? Of course, if all you have to think for the application of the convention, what would happen if all countries adopted this, right? So if all countries adopted a policy where at their physical border, they can decide to reject without assessing anyone who seeks protection, that would render the convention defunct, right? Essentially would mean no one can enter anywhere else legally to get protection. What they can do is they can try and get in an unauthorized way, and then once they're already physically in the territory, then the state has no choice but to tolerate their presence, right? But that cannot, as a matter of international law, that cannot be the correct outcome, that you end up with people having to breach the law in order to enjoy protection, if there is an alternative that is one that states are able to put in place. And I mentioned earlier the OAU convention, but the Cartagena Declaration has also said that they wish to reiterate the importance and the meaning of the principle of non-refoulement, which includes the prohibition of rejection at the frontier as a cornerstone of the international protection of refugees. So I think before we move to jurisdiction on the high seas. Maybe we'll do, because I'm conscious today's session is kind of back to being like a 3.5 hour session. We should not kind of run very long without a break. So we might take a 5 minute break now, just until 20 past or so, just people to get up and kind of, get a drink or what have you, and then we'll carry on with the second half, and then we'll do a proper break in the middle. But yeah, I think it's a good idea to have a short break now. So I will see you in 5 minutes. Right. Okay. So let's continue then and start talking about this notion of interdiction at sea, right? Which we've already alluded to with Avia's comment or question earlier. Um, and as I've suggested, there are two seminal cases here, which took different views or different interpretations as to the obligation that applies under the convention, at least, and in international law on the open seas, and that is the earlier case, which is a domestic case, the case in the U.S. Supreme Court called Sale versus Haitian Center Council, case from 1994, which is still good law in the United States. It's never been reversed by the Supreme Court. And on the other side, the case of Hearsay versus Italy, which is a case in the European Court of Human Rights, where nominally the framework for analysis was the European Convention of Human Rights, not the Refugee Convention as such, but the principles around jurisdiction and around reforma were the same, and so it's seen as having guiding power, as it were, in relation to reforma cases elsewhere. There have also been subsequent cases that have reiterated the principle of the Hersey case. The short and the long of it is to say that those are very different outcomes. My own view and the view, I think, of uh, the consensus view of the refugee law community was that the Supreme Court in the US was wrong. It was also the view of the Inter-American Commission of Human Rights when it heard the same case. Nevertheless, I say it remains good law, at least in that country. And so, to the extent the United States engages in interception on the open sea, that seems to be left uncovered under US law by its reform obligations under the Refugee Convention. So what was the Sale case about? So the Sale case concerned a executive order signed in this case by the American president, believe was signed by George Bush Sr. as he was um, president between 1988 and 1992, but the specific case arose under the Clinton administration, which hasn't revoked that executive order. And the executive order directed the US Coast Guard to intercept vessels that were arguably illegally transporting passengers from Haiti to the US and to return them to Haiti without determining whether they qualify as refugees. And this is against the background of great political instability in Haiti, which prompted large numbers of people to seek refuge elsewhere, primarily in the United States. And Haiti being not very far, but far enough to have international waters between itself and the United States, had boats trying to cross from Haiti to the US, and the interception happened in the open sea, right? Or in international waters. They would intercept boats and would escort them back to a port in or towards the port in Haiti without undertaking any assessment of why the individuals on those boats were there, whether they had protection claims or not. And the legal question for the court was, does that violate the specific provision under US domestic law that deals with essentially an implementation of the principle of non-refoulement in US law and Article 33 of the Refugee Convention, which for our purposes is where we focus. And so the majority in this case found the following. It said the drafters of the convention and the parties to the protocol may not have contemplated that anyone would gather fleeing refugees and return them to the very country they had desperately thought to escape. And those actions may even violate the spirit of Article 33, but a treaty cannot impose uncontemplated extraterritorial obligations on those ratified through no more than its general humanitarian intent. Right? So I find this a really interesting text, even in terms of wider debates around treaty interpretation and purposes. What what Justice Stevens is saying here essentially is that if the drafter had contemplated a case like this, which I mean, I find it strange to believe they wouldn't have, given we all know, I know it's Holocaust Memorial Day in Israel today. Um, we all are familiar, tragically, with the story of the St. Louis, which departed from Hamburg with ultimately Jewish refugees from mostly from Germany, trying to make it and being denied entry both by Cuba and by the United States, and was forced to turn back, right, to Hamburg, and with many of the people on board ending up perishing in the Holocaust, right? The idea that the drafters didn't have a scenario of interception or of non of refusal to dock in mind, I find unlikely, to put it mildly. But let's say that he's right, right? He says if they had thought about it, maybe they would have prohibited it, but they haven't prohibited it. So even though it may violate the spirit of the provision, this is extraterritorial, and so it can't be imposed on the United States. And it's he deemed it to be extraterritorial, despite the fact, and I think this was implicit in Avia's comments earlier, that uh, in order for the boat not to get to US territorial waters, something had to happen, right? So it's not as if the boat was, it's not as if those people were going to drift away anyway. It's they were physically stopped by force, right? So they were ordered not to enter the territorial waters. And so there was the exercise of control over those people by the US Coast Guard. That is the reason they were stopped. And so against this background, we will see that's precisely the understanding that the European Court of Human Rights in heresy applied to circumstances where where national force, right, a national military is exercising power over a civilian vessel in the open sea. The idea that that isn't a form of exercise of extraterritorial jurisdiction is, as I say, in my view, very unpersuasive, which is why, as well, the the dissent, took the view um, that to adopt a position like the majority really flies in the face of the purpose of the convention. It said the straightforward interpretation of the duty to not return is strongly reinforced by the convention's usage of the French term refouler. The ordinary meaning of refouler, as the majority concede, is to repulse, to push back, to repel. Thus construed, Article 31 of the convention reads, no contracting state shall expel, which means repulse, drive back, or repel a refugee in any manner whatsoever to the frontiers of territory where his life or freedom would be threatened. That, of course, is exactly what the government's doing, right? So ultimately, again, we don't know what would have been the individual determinations in relation to anyone or everyone on that boat. It might be that some of them would have not been found to be refugees, but to the extent there were people there who would need protection, they were pushed back to the country of origin where they would face real risk to their lives or freedom, right? And Justice Blackmun said in his dissent that's a clear breach of non-refoulement. And the Inter-American Commission on Human Rights agreed. It said the Supreme Court of the U.S. held that non-refoulement doesn't apply to Haitian interdicted on the open sea and not, or the high seas rather, and not in U.S. territory. The Commission doesn't agree with this finding. It shares the view of UNHCR that Article 33 has no geographical limitations. And one other reasons, and of course we haven't studied it yet. This will come, I believe, on Thursday. But one other interpretive reason to take the view that Article 33 is not territorially bound is that some other provisions explicitly reference territory. So there are some provisions, some rights under the convention that accrue to people who are present on the state's territory or who are in the state's territory. So the convention uses that term when it wanted to use that term, and it didn't use the term territory in relation to Article 33. Article 33 has no um, precondition to its application. It's as soon as jurisdiction over an individual kicks in, that Article 33 kicks in. And by definition, that's the first interaction with the individual that the state has. I mean, to relate back to my point, I think yesterday or the day before, about the declaratory nature of refugee law. At this point, when you are intercepting somebody, you don't know whether that person is or isn't a refugee. You have no idea, right? But the only way in which you will know is if you let them express a wish to apply for asylum and then have an assessment of that application. If you find that they have no grounds for protection, then by all means you can deport them, assuming there are no other human rights grounds that would allow them to stay. But until and unless you do that, you can't assume they have no protection claims before you've assessed them, right? And so Article 33 is that first interaction, that first point of contact between the state and the individual. That's why it's so key. That's why some people argue this is the core principle of international refugee law. Um, and to argue then that what states are not allowed to do in their territory, they are allowed to do on the open sea seems to be, uh, and I'll, to put it bluntly, an incorrect interpretation of the convention. And that's, as I've suggested, was the position, albeit in relation to the European Convention of Human Rights, that the European Court of Human Rights adopted in Hirsi versus Italy. So the Hirsi versus Italy case, and then I'll present it as well, and then I'll pause and see if there are any questions or comments on both of these cases. The Hirsi versus Italy case involved 11 Somali and 13 Eritrean nationals, and they were part of a group of about 200 people that left Libya in 2009 on board three boats that were bound for Italy. And this is a period, if you cast your mind back, some of you were very young, but nevertheless, this is a period when Muammar Gaddafi was still um, uh, the undeposed leader of Libya. And Italy has reached an agreement with Muammar Gaddafi to essentially make it worthwhile for him to try and stop boats from leaving Libya. And in many instances, that was successful. And in this instance, he wasn't. And at the same time, Somalia was subject to a very brutal war, a civil war. And Eritrea, as we know, and as we'll come back to discuss next week in relation to Israel, has been producing large-scale refugee movement. And so those two nationalities, or members of those two nationalities, were the applicants in this case. They were part of a group of 200 people who left Libya, and they tried to get to Italy. And if you look at the map of North Africa and Europe, you will see that the northern tip of Libya and the most southern areas of Italy are very, very close, particularly an island called Lampedusa, which has been the first kind of landing post of a lot of people who've crossed the Mediterranean. But despite being very close, there is some territory, there is some international water or some high seas between those two. So once you leave Libyan territorial waters, there is still space in the sea before you enter Italian territorial waters. And it's over there that the Italian Coast Guard ships were interdicting or intercepting this boat with Somalis and Eritreans, intercepting them and escorting them back up to the territorial waters of Libya and finding their way essentially back into Gaddafi's hands. So this whole episode happened, this whole very sorry episode happened on the 6th of May 2009. They were 35 miles south of Lampedusa. This is interestingly an area that Malta has a responsibility for, because And that's from the law of the sea. There's no reason you should know this particularly, but it's anecdotally an interesting feature that when you've got a body of water like the Mediterranean, there is a division under international law of the sea obligations between the different states surrounding that body of water when it comes to search and rescue. So there are search and rescue obligations when you've got a vessel in distress, and they apply in by definition in the high seas because in your own territorial waters, it's always your responsibility. And so, in fact, this area where the boat was intercepted was not supposed to have Italian Coast Guard ships at all. It was supposed to have Maltese ones to the extent a boat needed to be rescued. The reason the Italian boat went there, of course, is because it wanted to prevent the boat from once having left that Maltese area finding its way into Italian territorial waters, at which point jurisdiction would surely kick in. And they thought if they intercepted a boat in international waters, they would avoid or evade having that responsibility. So they were intercepted, and the passengers were transferred to the vessels, right? So this is an important additional fact, right? So in this case, it wasn't even the case that the boat itself was escorted. The individuals themselves were taken on board and were taken back to Tripoli, right? Those were the circumstances. Now, what the court had said about this was interesting in the way the legal argument was framed, right? And it's again perhaps an interesting example, and an interesting comparative example of how courts deal with trying to reach the narrowest ratio that they have to, right? And you will be familiar with this. This is obviously the case in domestic courts as well, in the Israeli Supreme Court, in other courts, that they try not to decide something they don't have to decide, and they try to decide whatever they do in the narrowest possible way, so they don't limit themselves in future cases. And so the court here was very clear to say we're not making some general point about extraterritorial jurisdiction. In fact, only in exceptional cases are acts of the contracting states that are performed or produce effects outside their territories constitute an exercise of jurisdiction. So these are not the usual cases, these are the exceptional cases. Um, but when do these cases apply? The court here, following a sequence of cases that it engaged with in the past, including ones which related to the operation of Turkish state agents in several African countries trying to capture political dissidents, particularly Öcalan, famously. Um, was to accept this idea that there can be the exercise of control and authority over an individual as essentially a segue to jurisdiction over that person. So the court reiterates this general principle. It says whenever the state through its agents operate operating outside its territory, exercises control and authority over an individual and thus jurisdiction. So following from this jurisdiction, the state is under an obligation under, in this case, Article 1 of the European Convention, but the equivalent would apply under the Refugee Convention to secure to that individual the rights and freedoms under the convention that are relevant to the situation of that individual. So again, without getting into too much international law for you that is beyond this module, some of you may be familiar with the notion of a functional approach to different areas of international law, which has often been applied in relation to occupation, has been most notably applied in relation to the question of whether Israel continued to occupy Gaza in a meaningful way after disengagement, and the argument being that of course it didn't to the full extent because it didn't have physical presence, but it did exercise some functions that exercise some forms of control that then prompted some responsibility. right? That's the functional approach, the idea that your obligations towards the individual extend as far as are relevant to the situation. So no one would have expected the Italian coastal vessel to make sure that someone whilst on board are able to marry, right? Or perhaps even to exercise in full the right to freedom of association. But the obligation in this case was a negative obligation, was the obligation not to subject that individual to inhuman or degrading treatment in the country to which they were to be returned, and that of course did apply, right? So that approach, that functional approach in this instance implied obligations pertaining to the non-return or non-reforma obligations, and so um, that obligation, as I say, arises from the idea that no one shall be subjected to torture or to inhumane or degrading treatment or punishment under this convention. The notion of jurisdiction comes back to Article 1 of the convention, which says that the high contracting parties shall secure to everyone within their jurisdiction the rights. And on that basis, the court found in this case that we've got individuals that were taken entirely on board ships of the Italian forces, right? So the Italian armed forces, the crews were Italian military personnel, right? And the court proceeds to then say, in the court's opinion, in the period between boarding the ships of the Italian armed forces and being handed over to the Libyan authorities, the applicants were under the continuous and exclusive de jure, so in law, and de facto, so in fact, control over the Italian authorities. And it didn't really matter whether the Italian Coast Guard intercepted because he thought the boat was in distress or not. That's not relevant. So the last sentence here is a bit obscure. You don't know what they mean by saying speculation as to the nature and purpose of the intervention, but that's probably what they mean. But that doesn't matter, right? Ultimately, what matters is you've intercepted a boat, you've taken people on board, you kept them under your control. They couldn't leave without your permission. You then take them back to Libya. It's pretty obvious you are exercising jurisdiction over them in that space. In the same way you took them to Libya, you could have allowed them to apply for asylum, right? That's the core idea. And in this context, the court says when the applicants were transferred to Libya, the Italian authorities knew, or indeed should have known, that there were insufficient guarantees protecting those concerns from the risk of being arbitrarily returned to the country of origin, having regard in particular to the lack of any asylum procedure and the impossibility of making the Libyan authorities recognize the refugees status granted by UNHCR. And here, this is an important point, of course, because Libya was a rare case in Africa. We saw the map, I think, in the first seminar, of a country that is not a signatory to any of the key human rights treaties. So not a signatory to the Refugee Convention, not a signatory to the ICPR, not a signatory to the OAU Convention. I think not even a signatory to the Convention Against Torture, but that I might be wrong on this. So ultimately you're returning someone to a place which is not their country of origin, right? So remember, this kind of harks back to where we started today. So non-refoulement here applies not because you're returning Somalis to Somalia or Eritreans to Eritrea, but you're returning them to a third country or a transit country through which they've transited or sought to transit to Europe. But that country is one where there is no effective provision of asylum to individuals who want to seek it, right? And it's that context that led UNHCR, indeed, some years before, but in understanding the whole notion of interception at sea, to issue its own conclusion, or the executive committee or ExCom of UNHCR several years before had said about interception measures, they should not result in asylum seekers and refugees being denied access to international protection, or in those in need of protection being returned either directly or indirectly to the frontiers of territories where their life or freedom would be threatened on account of a convention ground, or where the person has other grounds for protection based on international law. In other words, even if the basis for the person's protection claim isn't the Refugee Convention, but is, for instance, the Convention Against Torture or the ICPR or regional protection mechanisms, um, you must allow that person to engage in a process where that application is assessed rather than intercept them and send them without any assessment, right? That would be interception in those circumstances, even when it's involves indirect reforma, right? So it involves, in this case, like hearsay, a return not to the country of origin, but to a transit country or third country, that would constitute reform. So, I mean, to conclude that kind of segment, I would say um, it's not possible to say that there is a uniform position globally on the question of whether interception amounts to the exercise of jurisdiction, simply because we have this important jurisdiction where a court has taken the opposite view, albeit in a majority decision 30 something years ago. But my own view is that the interpretation that the European Court has adopted, and indeed other domestic courts have adopted in other instances, including in Italy and Greece, is the correct interpretation because it's faithful to the again to the rationale behind the convention. Because if it were possible to simply evade responsibility by getting your ships to leave your territorial waters, go into the open sea, and push boats back, right, through whichever means you deem appropriate, then that would undermine the possibility of people to seek and enjoy asylum elsewhere. And that would be that would counter the rationale of the convention, where those individuals should be receiving protection somewhere, albeit without specifying in the convention where that place would be. So that's the kind of second tranche. So before I move to the final tranche, which is the essentially the most pernicious, but also most challenging from a human rights law perspective to contest because of its context, which is stopping people essentially from leaving in the first instance. I just want to see whether there are any questions or points clarification.
No, I just wanted to say, like, a side comment
Sure.
that um, I had like a course with Dr. Vera, who's like our teacher for international human rights law.
Sure.
So and she shared with us the details about like the Italy case. And I
Sure.
have to say that this aspect of the case was unknown to me. Like um it's very nice to just see the case and just analyze it with the lens of refugees um like scope, because in her like class we discussed different topics that raised from the same case. So
Okay,
that
fascinating.
was my topic, and thank you so much for it.
Okay, fascinating. I mean, I'm sure. Look, I mean, the reality is, I probably wouldn't be able to teach properly the other aspects because my expertise in things like the law of the sea or search and rescue is very minimal. Yeah, ultimately in the refugee law community, this is considered to be a seminal case. It really is. It really has shifted, and in some ways. I will come a little bit later, probably after the break, to some of the what I call the externalization and containment mechanisms, and many of those mechanisms that were put in place by the European Union, by European states, and others are a direct response. I mean, there's no other way of thinking about them to the curtailing of their ability to operate by this judgment, right? It's because they can't intercept in the way they thought they could up to heresy, that they engage in other forms of prevention, containment, externalization. That's what I was suggesting at the very start of today. That's the kind of reality check that you've got one door being closed, another window being opened, right? Or depending on your metaphor, but it's this idea that the courts, I'd say the European Court, in my view, adopting the correct interpretation, the consequence of that not necessarily being that people are able to reach the European Union because there are other things that have now been put in place to stop them from doing so, right? So that's a wider context that I just want to offer, by way of context. But it's a good case, and I mean, in some ways, I also understand the court's reluctance to expand the ratio too much, right? So it was unkeen, it was clearly unkeen to say any operation on the high seas would engage jurisdiction in all circumstances, right? So there were specific facts of this case which were quite easily distinguishable because there was coercion, because people were brought on board. And in those circumstances, it became really very difficult to contest that jurisdiction applies. What would the court do is, a boat that, gently but firmly tried to block a civilian boat from continuing its path, right? And finding creative ways of pushing it back into, say, Libyan or other waters. I think would be an interesting test, because it's not clear that falls, not clear where that falls alongside that kind of specific ratio in the judgment. So let me talk about jurisdiction then, in the context of the European Roma rights case, where the story was a more common story now. I mean, actually, at that time, this is before various electronic verification mechanisms existed, and you could really prevent people from boarding simply by not granting them, not even issuing them a boarding pass um, before they are able to show that they have the correct visa documents. This is a case when the Czech Republic was not yet a member of the European Union, and so there was no freedom of movement between, when the case started, at least. It took a few years through the European Court of Human Rights, but the case started, it wasn't a European Union member state, and so people couldn't travel freely. They needed some sort of a visa. And in this case, this was a group of people who belonged to the Roma community in the Czech Republic, who believe that they are unprotected by the Czech state, right? Very much speaks to a theme we talked about yesterday about the state being, in this case, perhaps unwilling to protect them from various forms of persecution they arguably suffered in Czechia from other people, and they wanted to get to the United Kingdom because the United Kingdom at that point has already had the judgment that we talked about the other day, that acknowledged that non-state actors can be actors of persecution, and so people can obtain asylum. So ultimately, they wanted to board the flight to the UK in order to get asylum. That much is clear. And the UK realized that in some ways, perhaps this was again, the court closing a door and opening a door at the same time. They realized that the consequence of the UK judgment a few years back was that the UK is now an attractive destination to people who are fleeing persecution by non-state actors. And in this context, has decided, the Home Office, the UK Home Office, has decided to send UK immigration officers to Prague Airport to be at the airport, to be at the gate ultimately to a flight, and to do a form of ethnic profiling, right? Where it's not that they would stop everyone from the Czech Republic from boarding a flight to the UK, but they would stop people who they thought are potentially likely when they arrive in the UK to apply for asylum, right? And the context, the wider context for this is that there is and wasn't a mechanism by which people can apply for a so-called humanitarian visa. So they can't apply to get a visa. There would be a bridging visa that would get them to another state. And in that state, once they're there, to then apply for asylum. As we've discussed in the first seminar, you need to be outside your country in order to meet the refugee definition. So you can't get asylum whilst you're still in the country. And if you want to get to a country which is not a neighboring country, doesn't have a physical border, you need to get there somehow, usually by air or by sea, sometimes by trains, right? Or car. And if you want to get there legally, you would need some form of a visa. So if your country if, sorry, the country you want to enter doesn't require a visa, then you just travel. And when you arrive, you'll apply for asylum. If it requires a visa, but it issues it on arrival, same thing. You'll arrive there, and then when you are asked which visa do you want, you'll say, well, I'm here to apply for asylum. But in the circumstances where neither of these apply, where you need to get a different form of visa, then you need someone to check whether you would be eligible to get that visa or not. And today, what happens is that there is a regime in the European Union, in the United Kingdom, in various other places of so-called carrier sanctions. So if your airline doesn't check your travel documents and allows you onto the flight, and then it turns out when you land that you didn't have the correct travel documents, you didn't have a visa, then the airline could get penalized, could get financial sanctions for having done that, for having allowed you on, because once you arrive, then you're in the other state's jurisdiction, and then you can potentially apply for asylum or otherwise. So airlines don't do that, right? Airlines check whether your documents are valid or not. At the time of this operation, this was not in place, right? And so what the British state decided to do was to have a form of externalized, you can think of it in those terms, migration control exercise long before you entered the United Kingdom. Now, ever since then, things like the Eurostar exist, the Channel Tunnel, and actually, if you take the Eurostar from the UK to France or to Belgium, your passport check is done before you leave even. So you nominally you metaphorically already enter France before you've even left London, right? But that's because of also because of administrative convenience. But the fundamental point here was you were still in Prague, right? You were still at the airport, um, and and those officers, what they've done was to check, as I said, to do a form of ethnic profiling and to simply deny people who looked like they were Roma the ability to board the plane. And the question was, does this engage reformer, right? Or that was one question. The other question, which the court actually answered positively, was did these agents in their own activities discriminate against people on grounds of their ethnicity? And to that, the court actually said yes, right? It said you are distinguishing between different Czech nationals based on the fact that some of them are Roma and the others are not. That's prohibited under discrimination law, right? So under the provision in European Convention. But what this doesn't do is engage jurisdiction for the purposes of the Refugee Convention. And what was the construction that the court adopted to get there? It started by saying this is different than the Sale case, right? So Lord Hope in the House of Lords said the following. He said those who were dealt with, which is an interesting way of framing it, at Prague airport were in a different position than those who were turned back in the Haitian case, who were undoubtedly refugees as determined by Article 1A of the Convention when they were intercepted on the high sea, as assuming the other conditions were satisfied, they were outside their country of nationality. So what you see here is interestingly, Lord Hope, this is about 10 years after the Sale judgment, before the hearsay judgment. So it's an in-between case. And he essentially says we disagree with the UK, sorry, with the US Supreme Court. We would have found those persons to be within potentially the jurisdiction um, of the refugee convention. But here we've got a different story, and Lord Bingham described this most concretely. He said there would appear to be general acceptance of the principle that a person who leaves the state of his nationality and applies to the authorities of another state for asylum, whether at the frontier of the second state or from within it, right? This is very critical because he essentially again says if you are at the border, at the physical border, so if the Czech Republic had a physical border with the United Kingdom and you arrived at that border, right? If the persons from the Czech Republic instead went to the Czech-German border, say, physical border, they were to apply there, then a rejection there would amount to reforma. So he says there's a general acceptance of the principle that if you leave your state, you apply at the frontier or within a second state, you should not be rejected or returned to the first state without an appropriate inquiry into the persecution of which they claim to have a well-founded fear. But he said the principle cannot avail the applicant, the appellants who haven't left the Czech Republic nor presented themselves, save in a highly metaphorical sense, at the frontiers of the United Kingdom. Right. So essentially, it's to say, which I think is at the very least, I think, challengeable framework is to say it is perfectly fine for the UK to send its immigration officers to a foreign state and to act there as a barrier to someone boarding a flight, but that action alone does not trigger jurisdiction for the purposes of the Refugee Convention, right? And the same rationale has been adopted since in other cases, most notably the European Court of Justice had a case of a family from Aleppo, from Syria, who went to Lebanon and went to the Belgian embassy in Lebanon and said, we want to get a visa to get to Belgium to apply for asylum. Once we get to Belgium, because we can't go back to Syria and we are not protected in Lebanon. Lebanon's not a party to the convention. The rights are precarious to the extent they even exist. So we want to go to Belgium, and Belgium said no. And the question was, can this decision to deny them a visa be challengeable? So the administrative decision, an administrator, sitting in the Home Office or the equivalent, makes a decision not to issue someone with a visa. Does that decision, when the decision relates to someone's protection um, claim, right? So the decision to deny you a visa to travel somewhere as a tourist, say, in order to then be able to apply for asylum, is that decision an exercise of jurisdiction that triggers the obligations, including non-refoulement under the convention? If any court in the world takes the position that it does, uh, that would be groundbreaking, right? That would change the whole understanding of how we deem jurisdiction to apply in relation to asylum, because it would essentially cut that Gordian knot that links the need to leave the country with the lack of an obligation of another state to issue you with the legal means to get there, right? There's nothing in the convention that says you must issue refugees from other countries travel authorization, right, visa otherwise, to get to your territory. And there is something in the convention saying you have to leave your country, right? So to cut that Gordian knot, what you need is essentially to acknowledge that when you apply from out of the country to get to a country, to get to claim asylum, the decision to deny you entry amounts to an exercise of jurisdiction for the purposes of the convention. If that decision is based on a flat rejection rather than an assessment, for instance, of at least prima facie assessment of whether you have a ground for protection. That's, I say this at the same time acknowledging that no country has adopted this interpretation, no court adopted this interpretation. Were it to be adopted by only one country and not by others, that could be quite challenging for that one country because in the absence of other routes to legal protection, it may be disproportionately bombarded by people wanting to seek protection in that country. Were it to be adopted as a more general principle, say by the Court of Justice of the European Union, applying to the whole of the European Union, I think that would be an important move in international refugee law. Do I think it's likely to happen? Absolutely not. I think it's very unlikely to happen, certainly in the current climate. But that is the logical extension of the of that distinction that was drawn between physical or territorial jurisdiction and other forms of exercise of control over people in a way that affects their rights. So I think this is a very good time to pause. So I just want to see whether the European Roma rights case or the other stuff that I've just discussed in terms of visa regime, etc. Whether there are any questions or clarifications about that from anyone. Any comments? I think if no one is saying anything, I think what I suggest is we do let's say a 25-minute break or so, come back at it will be your 4:35. Yep, 4:35 Israel time. And then we'll go into externalization practices. And I think what we might do is we might leave. I don't think there'll be enough time to talk about exclusion properly. So if we finish a little bit early, we might finish a little bit early. We'll see how long the discussion of externalization takes us. So I will pause the recording and we'll resume the recording at this point. And I will reshare my screen. Sorry. Great. Can everyone see this? I think you can. Okay. So what I want to do for the last bit of today, and I said I think on reflection we probably end up finishing a little bit earlier rather than try to cram in the start of a different subject. And I think we're doing well with time, so I'm not concerned. And probably won't have an interim break, so we'll just go in one flow in this section. Is talk more generally about externalization practices, and I mean this very much flows from the discussion in the first part because it's the natural corollary of what I was saying in the first half about the way states essentially have been attempting to evade responsibility or dodge responsibility or transfer it to other countries for having to deal with asylum seekers. And the easiest thing um, is to simply not give them the right to enter, right, by denying them visas and enforcing it and having airlines, shipping companies, etc., enforce it. And that works to a certain extent, right? It allows um, states to avoid, say, to take a very concrete example I was just talking about this morning in UK Parliament, in a context, the UK government decided to stop issuing student visas to people from certain countries like Cameroon, Myanmar, because students would end up kind of being in the UK and then at a certain point applying for asylum for the reasons we've discussed in the first seminar. So they just won't give student visas, and of course this is a classic case of adopting a so-called non-entrée policy, so a policy which really prevents um, people from entering through legal means. So that's an ideal scenario for states. People just end up not arriving. Of course, then some people end up trying to arrive nonetheless, right? And then you get people trying to enter in a clandestine well. So trying to get snuck through a lorry or truck, trying to cross in a small boat, getting in on a false passport, getting in on the false pretense when you do actually get a visa. So states may end up with people on their territory who they would much rather not have to deal with. Um, so would much rather have someone else deal with them, either just for the processing or more generally, just take responsibility over that person. States may also try to do something that is an in-between measure, right? They may try to say, um, we realize, the fact that we don't issue someone visa will stop them from traveling directly, but it won't stop them from traveling through a transit country, right? So the fact that an Eritrean won't be able to get a visa to come to the UK doesn't won't stop them from getting to Libya and trying then to cross the Mediterranean by boat and then trying to make their journey overland and ultimately on a small boat to the UK. So why don't we try to cut this trail that Eritrean is trying to pursue, um, not just by denying them a visa, because that we will do, but by getting the Libyans to stop them from either boarding the ship or the boat or the small boat that tries to cross the Mediterranean, or if they did manage to, and the boat did manage to evade the Coast Guard, to try and stop that boat before it leaves Libyan territorial waters, right? Because once it's left Libyan territorial waters, it's in the open sea. We get into the territory of the Hirsi case that we've discussed earlier. So those are some of the scenarios, some of the cases or framings that I want us to be exploring. So the first point of entry I want us to have for this discussion is a form of a definition of what externalization means, and this is lifted from the Refugee Law Initiative, to which I belong as well. It's a group of scholars, under an umbrella that sits physically at the University of London, but has people operating the world over. And the Refugee Law Initiative issued a declaration on externalization and asylum a few years ago, in which it says externalization is the process of shifting functions that are normally undertaken by a state within its own territory so that they take place in part or in whole outside its territory. Such externalized functions might be implemented by a state unilaterally, jointly with other states, or with entities including international organizations and private actors, or through partially or wholly, sorry, delegating the functions to other states or entities, right? So this is a full, as you were, coverage of the type of things that may involve externalization, and we will go through some specific functions now. So I think the two kind of overarching questions we want to consider is um, what is the relationship between externalization and responsibility sharing, given that if we hark back to the preamble to the Refugee Convention, we were actually saying the Refugee Convention saw it as a desirable thing for states to collaborate, right? It just didn't set up any mechanism for them to do so. So what is wrong, to put it bluntly, with um, the UK having an agreement with Rwanda to quote unquote share the responsibility over asylum seekers? Why is that bad, right? So that's one way of asking the question. The second, I think, question is, do these practices undermine the 51 Convention, right? So we can think about different things that would explicitly undermine the convention, right? So an explicit act of reforma to the state of origin obviously undermines the Refugee Convention. Denial of rights that you're supposed to deny to grant rather under the convention would obviously undermine the convention. Is externalization as such a form of undermining the convention, right? So those I think are questions, are overarching questions that we may want to probe as we proceed. So this is just a reminder, right? What does the um, Refugee Convention says? It says the grant of asylum may place unduly heavy burdens on certain countries, and a satisfactory solution of a problem to which the UN had recognized the international scope and nature cannot be achieved without international cooperation. So this seemed to have indicated that actually um, some countries may be unduly burdened. Usually, it would be neighboring countries, as we know, because that's where three-quarters of the refugees end up. So maybe agreements or maybe some arrangements for international um, responsibility sharing are okay, right? So, one classic example for responsibility sharing is the arrangement within the European Union, right? So the idea that there is an assumption that the first country in which you enter the European Union has a responsibility to deal with an asylum seeker. That's many people would characterize as a counter responsibility sharing mechanism, right? It says we've got one union, one European Union, and we expect actually disproportionately some states to share the responsibility for what is ultimately a European Union question, right? Which is the reception of asylum seekers, because it has EU law on it and EU jurisdiction. Now, since the Dublin regulation, we now have moved on to a new asylum framework that will come into effect this July, and in that framework, there is actually an extent to which there will be some balancing of that initial form of counter responsibility sharing, where states would compensate other states financially for the fact that they host fewer refugees, where there would be a potential for a transfer of people within the European Union when certain states have capacity. So, and Ukraine, of course, we saw as an example of a case where there was actually a form of allowing refugees themselves to make choices, which did lend itself to a more equitable spread of refugees, albeit still one where most refugees are hosted by a limited number of countries, right? So this is to put this in context, right? So we've got one area in the world that has attempted regionally to create a form of responsibility sharing. It has done so in a way that is not seen to be very equitable. At least the origins of it were not very equitable. It may be shifting in that direction, but the key thing about the European Union as a unit, right, and something that was, of course, tested at different times. Certain periods, Greece was deemed to not have proper asylum facilities. Hungary, certainly for many years, was seen as a country where certain groups of asylum seekers could not get a fair hearing, and other countries had various challenges to their asylum system. But as a general rule, the overarching assumption of the European Union is that any country in the European Union is subject to the same body of asylum law, which is EU law as interpreted and applied by the Court of Justice, that they are all committed to the principles of the Refugee Convention, that they all have a degree of the rule of law, that they are all signatories, of course, to the Refugee Convention itself. And so a transfer between EU member states does not evoke the challenges per se of some of the externalization measures or agreements that we will come to in other parts of the world, right? It's not a case of an agreement between a global north country, say like the United Kingdom, and a global south country, say like Rwanda. It's an agreement between countries that are part of the same global north unit, the European Union, and so poses fewer problems, right? So that's I think an important qualifier to the discussion we're going to have, because when people talk about externalization, when they talk about um, this shifting of responsibility, they don't ordinarily include in their understanding the practices within the European Union under Dublin, even though nominally they may fit that framework, because the whole context in which they're done is very different than virtually any other um, manifestation of externalization that we're gonna be thinking about. So that's my way of just introducing ourselves into this discussion. So you can say that there can be three types of responsibility sharing for refugees. There can be physical responsibility sharing, where you're sharing people, right? You're moving people across borders. That's the most crude way. There is financial responsibility sharing. So you accept, as the European Union, as I said, does, that the question of refugee protection is not a EU member state specific question, but it's a question for the Union. And so if one country has more refugees to host than others, then other countries have to step in and compensate to some extent. It's also the case that some in some instances, global north countries, quote unquote, compensate other countries in the global south for hosting refugees. We will come later to agreements such as, or statements such as the one between the European Union and Turkey, but that very much involved a lump sum and repeated lump sum payments by the European Union to Turkey, ultimately for performing a function that, if Turkey wasn't performing, the European Union would have ended up having to perform, at least in part, because if Turkey had allowed people to leave uninterrupted, many more would have ended up in the European Union, and the European Union would then bear the cost, at least initially. This is a wider debate around refugee protection and do you consider refugees to be a net benefit or a net cost financially? It's obviously very simplistic to have a broad brush view on this, but I think it's fair to say that in the short term, in the very immediate arrival, obviously refugees entail a cost because you need to create infrastructure, you need to provide basic necessities, etc. Longer term, in many instances, refugees are a net benefit to the economy. But in that short term, it's understandable that states may expect to be quote unquote compensated, but for refugee reception and protection. Interestingly, and this is a bit of a sideway note, but I'll make it nonetheless. The Refugee Convention says nothing, of course, about the state of origin. So the whole framework of the Refugee Convention is directed towards what the state of asylum is to do. And there's nothing in this convention that relates to what that means in terms of perhaps, for instance, a form of compensation from the state of origin for the fact that it imposed on other states a burden by its practices, and that's it's an interesting kind of legal question, right? Can you perhaps use wider general principles of international law and say states that have produced refugees need to, in some way or another, ultimately compensate for that? Other states that ended up hosting refugees as a result. There is nothing in refugee law that mandates this. Um, but that's just as an aside to the wider understanding of the kind of the financial components when we're thinking about externalization.
I-
So that's
Isn't
fine.
is
Sorry,
it
go ahead.
isn't it a bit redundant to even think about states that produce refugees to compensate. I mean, I think about Syria or Afghanistan. These are states so far behind, both in their um, moral rights, civil rights, and financial situation that they would never even think about, even and probably don't have even the means to compensate countries that take their people. And would they want? I mean, they threw them away because they hate them or they prosecute them.
Sure. I suppose the partial answer to this is that um, if there was a principle in international laws that states have to compensate in the same way they have to compensate, for instance, if they destroy property or they destroy infrastructure, then the question whether the state likes the fact that it's subject to this rule shouldn't be the reason to apply it or not to apply it. Whether states are able to pay is again, it's context dependent. And there are instances where the number of people that's refugees that states produce are not of the scale of Syria, etc. But you are right, and I think at heart the reasons you articulate are probably the reason that at no point did the drafters even consider including a section like this in the convention or in subsequent, regional conventions. So I think you're onto that, right, to something there. I mean, ultimately, the convention is very much oriented towards the obligations the rest of the world, ultimately through an individual member state have towards people whose own state has failed, right? That's the context in which the convention operates. And so in a way it's not interested in how that state settles the score if it does with a state of origin. Could the state find other ways of exerting payment for what it's been forced to do? As I said, there's also a debate as to whether we should think about refugees in that way, whether we should think about it as a financial cost, or whether we should acknowledge firstly that many of them end up contributing in a way that becomes a financial asset, but also that it's a moral responsibility and we shouldn't quantify it. The reason I'm making this point is that some of the agreements around responsibility sharing that we will come to very much are in the spirit of thinking that in order to convince or persuade a country in the global south to take in people who otherwise would be the responsibility of a global north country, the way in which you convince them is by partly giving them money for it, right? That has been the way of the world in the last decade or two, and I think that's in that context it's interesting to think about then the gap that exists in relation to the country of origin and in its role in this, right? So that's the on financial responsibility sharing. And of course, the best way perhaps of harmonization of responsibility sharing is to share policy, right? It's to have a harmonized policy. That is the aim of the European Union. When that happens, then the need for the sort of protections from the effects of externalization become weaker, right? Because you find yourself in a modality where your presumption is that if somebody is in Spain or in France or in Sweden or in Slovakia, they are supposed to be subject to the same asylum policy, the same rules, the same jurisprudence. As we know, this may be an idealized vision rather than the reality, but that is at least the model specifically the EU has been formalized on. And I think the last thing I want to say by way of this introduction to the responsibility sharing concept is what the Global Compact on Refugees had to say about this. So this is a document that is a non-binding compact or declaration from a few years ago, 2018, signed in New York alongside another global compact, the Global Compact on Regular and Orderly Migrate and Safe Migration. And the Global Compact addressed this question. And rather than say externalization, right? So those practices that I was describing are always legal or always illegal. In a way, it dodged that bullet or or ducked that question by saying what these agreements must do. And it's saying these agreements, in order essentially to be legal, they need to be in line with international refugee and human rights law, and they need to enhance refugee protection and prospects for durable solution. Durable solutions being a form of integration of refugees into the state, or ultimately naturalization, or in certain instances repatriation when conditions allow, right? So rather than say the global compact, you cannot have an agreement between two countries to quote unquote share the responsibility for refugees. The global compact says if you are going to have agreements, make sure they include A, B, C, and D, right? So that's been the pragmatic approach, perhaps that the international community adopted. This is, as I say, 2018, to what has up to that point already started becoming a common practice, and has since uh, escalated much further, right, to a level where some people would argue now externalization is the norm rather than the exception. Right. So what does externalization include? And this is something I touched on in the introduction. It can involve both pushbacks and pullbacks. So pushbacks is the practice where you intercept, you force back people without assessing their entry or protection claims. Um, it's widespread and systematic, as I've mentioned earlier, across migration routes, like in Greece and Hungary. And increasingly, it's done extraterritorially, so not done at your border, which would amount to to reforma, as I've mentioned before the break. And it's done either unilaterally or it's done in cooperation between states. Pullback is this notion of containment. It's when the third state or the transfer state is exercising a function of prevention or containment of a person who wishes not to remain in that state, and of course not to return to their country of origin, but to reach another state, right? They want to get from Libya to Europe. They are originally from Eritrea. They have no interest in remaining in Libya. Libya, on its face, should also not have any interest in them remaining in Libya, but is getting compensated financially or otherwise for making an effort to stop them from leaving Libya, right? And indeed, in some instances, perhaps even for returning them forcibly to their country of origin. So what are the limits of legality here? So I think there are several things that we need to consider. The first is that if there is effective control or complicity, then the responsibility remains, right? So this is the principle that we saw in the Hersey case, right? The fact that you are operating beyond your borders, if you still have effective control over the person, and that's how you're preventing them from proceeding, then you have responsibility. Similarly, if you're complicit in somebody else's activity in a direct way, right? If you are providing them the means by which they are intercepting, for instance, then you have responsibility. I mean, this follows wider principles in international law of state responsibility, so there's nothing specific or new about this here. It's also the case that if you delegate your responsibility for border control to cooperating actors, that doesn't evade your responsibility, right? So the fact that you hire a private company to be doing your border control, um, it's still your border that is being controlled. That power is delegated to them. It can be retracted, as we know with any power. You principle of administrative law, which I'm sure you're familiar with, that you can't delegate powers you don't have. So if those were originally your powers, the fact you've delegated them does not undermine in international refugee law your own responsibility. And thirdly, that if you are operating in vis-a-vis another state, like in the context of Libya or Tunisia or Niger in the context of containment in Africa, then you need that state's consent. I mean, that might be an obvious point, but it's in the world where we're in, where various countries seem to operate in breach of these principles. I think that's it's an important um, proviso to offer. So with that in mind, I want to zoom in on the UK Rwanda case study. Before I do that, I want to just sketch out some of the examples that exist globally for this form of responsibility sharing, just to get a sense of how pervasive those are. So um, before I do that, maybe I'll invite you to think from your readings, not for this course necessarily, but over the years, which cases kind of spring to mind of countries that have thought to evade their own responsibility by having agreements with another state to handle refugee claims, or by pushing them or intercepting them and sending them to another state? Well, what are some cases you've come across?
Maybe the US and El Salvador, right? There's something going on there recently. And there was also something with Israel that it wanted to cooperate with Sudan, I think, right?
Well, he wanted to cooperate, I mean, or cooperate, he wanted an agreement with Rwanda and Uganda in relation to Sudanese, but you're absolutely right. So we'll come back. I mean, the UK Rwanda case cross references Israel. So we will talk about this. We'll also talk about this with Shacha next week. But you mentioned the US and El Salvador. So there's an interesting point here, right? Which is the distinction between the more recent kind of attempts by the Trump administration to send people without a formal third safe country agreement to Bukele's El Salvador, right? Primarily to send Venezuelans, supposed gang members from Venezuela. Um, that's arguably not even a third safe country agreement because it doesn't even pretend to be one. But the US had, under the Biden administration, a set of agreements with three countries, in fact, in Central America, with Nicaragua, with El Salvador, and with Guatemala, that all involved an attempt to get people who arrived in the United States and who were from countries other than the country to which they were going to be sent to be processed essentially and potentially receive, if they were eligible, protection in those countries um, as refugees rather than in the United States. And those countries are refugee convention signatories, but the people who were going to be sent there did not necessarily have any connection to those states, didn't necessarily even transit through those states. And that cooperation agreement was put in place. It was implemented to a limited extent, but that was a clear manifestation of a so-called third safe country agreement. The U.S. has also signed one with its neighbor to the north, right? And that agreement, in fact, has been challenged in the Canadian courts and initially found to be breaching the Canadian Constitution, and then subsequently found to not breach it. So the US and Canada maintain an ongoing agreement which does not apply to the nationals of their respective states, but to third country nationals, so to people who arrive in the United States or in Canada, respectively, and want to cross to the other state. So as long as that person has first been in the other territory, they can be returned to that country on the assumption that in that country they don't suffer persecution, right? So there's a built-in assumption, right, that say someone who's originally from El Salvador ends up in the United States, but believe that they can't get proper protection in the US and crosses the border to Canada, Canada is allowed under this agreement to send them back to the United States without assessing their application, premised on the idea that the United States is safe for them, right? Very, um, and the agreement was challenged on these grounds in the UK, in the Canadian Supreme Court, in the sense that even though there's a guarantee in the agreement that they would be allowed to apply for asylum in the United States, etc., um, it in a way it is premised on the idea that people from certain countries are safe in the transit country, in this case, that they have transferred through. So the US-Canada agreement is in that sense very similar to the Dublin arrangements in the European Union. It's the idea that you can return people to the first country within the bigger unit that they have entered. So that's one set of agreements. So the United States with some of its not near neighbors to the south and its immediate neighbor to the north. What other agreements do you recall or do you have in mind?
I don't remember the details, but
Sure.
wasn't there an agreement? I remember a few years ago about the Sudanese and Eritrean immigrants in Israel. It was at least attempted between Netanyahu and the EU, try
Yeah,
to
well,
give them
that's
some.
Sure. Well, that's what Itamar was alluding to earlier. So that's the
Ah,
thing that's the agreement that we're going to come to, right? So the agreement.
okay.
So there were two phases. In fact, I'll stand corrected. So because you were talking about two separate things, even though they relate to the same group of people. So there was an agreement or a secret set of agreements between Israel and Rwanda and Uganda in relation to Sudanese and Eritrean asylum seekers, which is the subject of, as I say, the references in the UK case that I'm about to come to, and we're certainly safe, so-called safe third country agreement within the externalization framework. There was also a different agreement that you're right to remember, was very, very short-lived. And by very short-lived, I mean 12 hours. That the UNHCR has signed with Israel under the Netanyahu government in 2018, that was in those 12 hours celebrated by Netanyahu publicly as having been the first instance, in his words, where UNHCR has facilitated the transfer from a first world country or a global north country to other countries in the global north of refugees. So that agreement was going to have half of the Eritrean and Sudanese in Israel get protection in Israel, and the other half was supposed to get protection in other countries, probably Canada, Sweden, and others in Europe, under the aegis of UNHCR. So this was going to be a resettlement scheme of those persons there, having been already recognized as refugees under this scheme. This never happened because within the 12 hours, there was a very big political backlash within Netanyahu's own political camp that prompted him to retract the agreement. And I say 12 hours because he was literally 12 hours. It was an evening to morning operation. The agreement itself was done over months by UNHCR, and Netanyahu was not wrong that it was an unusual, and if not the only case of UNHCR agreeing to help people be relocated from a country that is considered to be in the global north to other countries in the global north. So that's a good indication. Anyone
Is
remembers?
there maybe something regarding North Korea and China? I'm not sure that that's externalization. They're just bringing them maybe back to North Korea, but maybe something
Yeah, I
along
don't
those
think China.
lines.
Yeah, I mean, Well, there's certainly, I mean, in that case, this is strictly reformer, right? So the China's practices have been pretty hectic, right? They have essentially if someone from North Korea is found in China, they are returned to North Korea, but that is returning people to the country from which they're fleeing. So that's a different beast, right? And that's very obviously breaching the Refugee Convention. But not that's not within our frame. So um, anyone can think I've actually mentioned it briefly earlier. Um,
Maybe I don't remember exactly, but I know that Germany had an agreement, maybe with Greece or France.
Right. So again, the European Union as a whole has this arrangement for responsibility sharing called the Dublin Regulation that says that the first country in which you enter the European Union has a responsibility in most cases to deal with asylum applications. There are exceptions to this, but we're not this module doesn't deal with EU law specifically, so I'm not getting into the exceptions here. So Germany, so if somebody has entered the EU first through Greece and then ended up in Germany, then in certain circumstances Germany would be able to return them to Greece. The UK could have returned people to other EU countries when he was a member. It no longer is, so it's no longer part of that scheme. So that's not the kind of type of or the cases I'm thinking of. But I did mention the EU earlier in a different context. So just a last call for examples before I talk about them. So the other two places where there have been clear cut, as it were, examples of externalization uh, were cases related to the EU and cases related to Australia. So starting with Australia, we've had instances where Australia has signed agreements with Nauru and Papua New Guinea, which are neighboring countries, for there to be refugee processing and ultimately hosting in those countries, right? So people who had arrived in Australia and who haven't been intercepted would be taken to those other countries, and in those countries they would be processed, and if they get asylum, they would still not be allowed back into Australia. They would have to remain in those two countries. That's been one case. And the European Union has reached a one-for-one type agreement, arguably, with Turkey, which says that for any person, this was back in 2016, an agreement that never got a legal force. It was a statement of principles between leaders of the European Union and the Turkish president. And the idea was that for any person that um, the European Union returns to Turkey having crossed irregularly or illegally, usually by boat from one of the closest islands to Greece on the Turkish side to the Greek side, the European Union would accept into its territory someone who UNHCR assesses to have protection needs that are particularly make them particularly vulnerable, right? So there was going to be a one-for-one agreement coupled with the European Union paying Turkey quite a bit of money for essentially hosting refugees on its territory. And then the United Kingdom specifically has had an agreement more recently, or an attempted agreement with Albania to try and have sorry, Italy. Why did I say United Kingdom? Because I'm thinking already about the next point in terms of Rwanda. So Italy had a specific agreement with a non-European Union country, Albania, to try and have people who arrive in Italy be taken to Albania in order to be assessed there. And if they're found to be refugees, they'd be allowed back into the United Kingdom. Uh, again into Italy rather. If not, if they're not found to be refugees, Albania could do what he wanted with them, right? So an Italian court assessed this agreement last year and found it to be breaching the Italian constitution and breaching also international obligations of Italy. So that agreement has never kind of really picked up. So this now takes me to what the UK has tried to do with the Republic of Rwanda. And this story kind of dates back to 2022, April 2022, under the Boris Johnson government, where the UK and Rwanda sign a partnership agreement, the APA. Rwanda gets all sorts of financial assistance and benefits and investment in its economy, a form of partnership. And Rwanda also agrees to take in people who arrive in the United Kingdom irregularly, right? So usually small boats, but through other means. Um, those people virtually in all cases have never been to Rwanda, so it's not an agreement to return people to a place through which they have transited, but rather an agreement to simply send them to another corner of the world. So you could have an Afghani woman who managed to be smuggled across Europe to the United Kingdom, would be sent to Rwanda, to which she has zero connection. And Rwanda would then be processing its asylum application. If it were to apply for asylum, it committed itself to undertaking asylum processing if people apply, and to giving people status if they're found to have reasons to do so. It also committed not to send people back to their country of origin if it would breach non-refoulement, um, and it committed to having a recourse to a legal system for appealing these sorts of decisions. This um, the first kind of transfers or attempts were attempted in the summer of that year, so several months later. And there were interim measures that were put in place by, incidentally, the European Court of Human Rights. So the British courts initially would not stop the transfers, but there was an injunction by the European Court of Human Rights saying, ultimately, if this practice is found to be unlawful, then this is irreversible once you've sent people back. The UK said, we'll send them to Rwanda, but if you, the court, find that this is unlawful, we'll take them back, right? And ultimately, in the European Court of Human Rights, the court said this is a classic case of irreparable harm that kind of requires an injunction. So it issued an injunction, and then the case went through the British court system. So the High Court, the lowest level judicial review court, upheld the removals, but the Court of Appeal in the summer and in the following summer, and then ultimately November 2023, the UK Supreme Court quashed that policy. Now, this was a fascinating case because um, this was a um, this was a transfer agreement that ultimately was was done pursuant to legislative changes, right? So there was primary legislation that allowed the Home Secretary, so allowed the relevant minister to reach an agreement for such transfers. But of course, every specific agreement is subject to judicial review, right? So the UK doesn't have the capacity for courts to strike down primary legislation. So you can't have an act of parliament quashed by a court, but you can have individual ministerial decisions, including an agreement that a minister um, is following an international agreement in pursuing this sort of transfer that is judicially reviewable and can be quashed. And this is what happened in this case. So essentially, the court found that this breaches the UK's international law obligations, and as a result, it's domestic law. So it breached, the court found, both the Refugee Convention and the European Convention of Human Rights and various human rights treaties. And as a result, transfer at that point in time could not be made. What the court did not find is that transfers per se, under any circumstances, would be unlawful. So it did not find that externalization practices per se are a breach of the Refugee Convention. And I'll come in a few minutes to how the court analyzed this specific case. But this is a very critical point, right? Because in some ways, the judgment was celebrated, I think, correctly by people who thought it was the right decision in terms of the specific circumstances, but it simply served at the same time to double down on the overall principle. And the overall principle is that the Refugee Convention prevents states from sending people to any place where their life or freedom would be in danger. But the Refugee Convention does not guarantee a refugee the right to receive asylum in a country of their choosing, right? So that's the important distinction. So a refugee cannot say, a refugee coming to having entered the European Union through Greece and making their way by land to Germany cannot say under refugee law, I have a right, and there's an opposing duty. I have a right to get asylum specifically in Germany. What the refugee can say is, I have a right to be recognized as a refugee if I meet the refugee definition. And the country where I've ended up, if it's not going to undertake that assessment itself, if it decides to transfer me somewhere else, that somewhere else has to be a place which is equally committed to assessing my asylum application to see whether I meet the refugee definition conditions, and if I do, to grant me the rights under the convention. So that is a very important distinction, right? So there's no right to asylum in a specific state, but there is a right to have an asylum application ultimately assessed somewhere, because if that doesn't happen, then a person may ultimately be subject to reform, right? And that's the terrain, that's the complicated terrain in which refugee law operates. That an individual can't come to a decision maker having just arrived at the border and say, I'm an asylum seeker, I meet the refugee definition, I demand to be granted asylum in this country. What they can say is, I demand not to be returned to a place of danger to me. Now, ordinarily, this would translate to that country then undertaking an asylum assessment and having found that that person meets the asylum, the refugee definition, deciding to grant it itself. But if that state at the point at which the person entered says, I'm going to send you somewhere else, but that somewhere else is a suitable place, in terms of its commitment and in law and in fact, then that decision to transfer is not necessarily in breach of the Refugee Convention, right? And that is the core of arrangements like the Dublin arrangements in the European Union, and that was the core ratio ultimately of the core judgment. So the core judgment here said, in the circumstances of Rwanda, as presented to us by the UNHCR and by other applicants, there are not sufficient guarantees in place to allow for this transfer to take place. Rwanda, in other words, is not a safe country for these individuals, but there is no obligation in refugee law for the UK to be the one taking responsibility for those individuals. And I mean, I would say even more contentiously, the court did not accept the idea that the person needed to have some sort of link to the country to which they're being sent. So at the very least, having transferred through that country, having spent a period through that country. So there's no obligation for that third safe country with which a country has reached an agreement to have any meaningful connection to the person they're going to assess, right? What that country needs to do is to be a country that operates according to conditions that meet the international obligations, right? So the subsequent kind of moves from the UK government in relation to the Rwanda agreement was that they proceeded to sign a new treaty and to pass an act of parliament, essentially saying, which was quite an extraordinary moment in rule of law terms. The Supreme Court said Rwanda is not safe, but we Parliament say it is safe, and no courts can challenge our assessment that it is safe. Now, I mentioned earlier the UK doesn't have a form of judicial review that allows for striking down primary legislation. I think this was probably the closest moment that a court might have claimed that power, because the UK also doesn't have a codified constitution. So the extent of the court's powers are something that is a fluid concept. The agreement never got implemented because what happened 3 months after that was that this should read July 2024, not 2025 on the slide. I'll correct this later. There was a new UK government, the Keir Starmer government, scrapped this scheme. So it basically said we're not going to implement the Rwanda plan, and so he never got challenged. My own view is that if it had got challenged, there would have been a strong case that this should have been the first time, a court would potentially strike down legislation for really breaching the rule of law. So the idea that you make a factual determination as Parliament that is contradicting a judgment of the court is was quite extraordinary, but we didn't get there, and I may be wrong, and the court might have not done it. So that's a side kind of domestic UK law point that's not that important for this module. So I want to then finally just talk about why or how the court reached its judgment. So as I've suggested, the court's judgment was not premised on saying third safe country agreements are prohibited. Didn't say that. Nor was the court saying they are always at the discretion of the executive. So we are letting the executive determine whether somewhere else is safe. They have what's in US law is often referred to as plenary power, right? So they can make determinations. We're not going to intervene in their judgment call about another country. So it neither said Rwanda is always safe, nor did it say Rwanda is always unsafe as a country to transfer people. It said we have to make a factual determination. We're going to hear from various interveners as to what are the probabilities here? What is the most likely assessment of the circumstances? And the court was presented by evidence. And if you recall, I said in the first seminar, I think, or the second, that UNHCR has this status under the Refugee Convention where it has a supervisory role and countries are expected to coordinate and collaborate with it. And one of the ways in which countries are supposed to do that is to allow the UNHCR to intervene as an amicus in various cases, which is what it's done in this case. And UNHCR has intervened, which is not usual for it to do in relation to agreements between states. It's actually relatively rare. The UNHCR decided to intervene, and it said that the conditions in Rwanda are problematic. And so ultimately, the judgment says that the evidence shows there are substantial grounds for believing there's a real risk that asylum claims will not be determined properly, and that asylum seekers will therefore be at risk of being returned either directly or indirectly to their country of origin. In other words, it was not persuaded on the evidence that the asylum system in Rwanda functions in a way that is um, giving us sufficient guarantees. And indeed, the UK, to some extent, acknowledged that the Rwanda system was far from perfect because it, in the agreement itself, offered to help Rwanda in capacity building. It actually offered Rwanda to have various people from the UK Home Office go to Rwanda to help with asylum applications. It even offered for judges from the UK to go and sit as a form of a hybrid appellate court in Rwanda. And what the court said that these changes need to eliminate that risk, and they may be delivered in the future, but we are making a decision today. They were not shown to be in place when the lawfulness of the Rwanda plan had to be considered in these proceedings. So it's a very contingent type of judgment in the sense that it doesn't say Rwanda can never be a safe country for people to be transferred to, but it says when you sign this agreement, you want to start sending people to Rwanda tomorrow morning. If you send them to Rwanda tomorrow morning, there isn't a system in place in Rwanda that gives us sufficient guarantees. And one of the reasons, perhaps a core reason, the court reached this determination in relation to Rwanda was premised on Rwanda's former agreements with Israel and the account of those agreements by UNHCR. So the judgment, and this is a quote from the judgment, says Israel entered an agreement with Rwanda at the end of 2013, under which persons from Eritrea and Sudan who sought asylum in Israel were removed to Rwanda for their claims to be processed there. The agreement continued in operation until 2018. It was considered by the Supreme Court of Israel, and it included an explicit undertaking of Rwanda, according to which deportees will enjoy human rights and freedoms, and the principle of non-refoulement should be complied with. And it referred to the ability of the deportee to file a request for asylum. So you might say, so far, so good, except that the court goes on to say there is no dispute that persons who were relocated under this agreement suffered serious breaches of their rights under the Refugee Convention. The court said UNHCR found that asylum seekers who arrived in Rwanda under the agreements were routinely moved clandestinely to Uganda, and there was evidence relating to more than 100 Eritrean and Sudanese nationals who had arrived and had been taken to the Ugandan border or put on flights to Uganda. In some cases, they were referred to Eritrea itself, there was an attempt for them to be referred to Eritrea, and that had been prevented by UNHCR. And the Rwandan government's response to this evidence lacked substance. So it's quite a strong statement by a national Supreme Court in relation to the practice of another state. Essentially said the Rwandan government's not given us any persuasive answer to why these things have happened. And the court proceeded to say, although ministers and officials were aware of the Israel-Rwanda agreement and the problems which arose under it, they do not appear to have investigated why it had failed or attempted to obtain information about the terms of these agreements or the assurances the Rwandan government had given. And they go on to say, in the decisions in this agreement, the Secretary of State asserted the Israel-Rwanda agreement was irrelevant. It was submitted that it was a different agreement. It was a few years ago, and it could shed no light on whether the government of Rwanda could be relied on to comply with its assurances, to which the court says, although the terms of the Israel-Rwanda agreement may well have been different, and it ceased to operate 5 years ago, it is nonetheless a recent agreement for the transfer of asylum seekers for processing in Rwanda, under which the Rwanda government undertook to comply with non-refoulement. Its apparent failure to fulfill that undertaking is relevant to an assessment of the risk of refoulement under the arrangements entered into with the government of the United Kingdom. And it proceeds to say intentions and aspirations do not necessarily correspond to reality. Again, in British understatement terms, that's quite a strong um, rebuke of this agreement. It says the question is whether they are achievable in practice. That is illustrated by the history of Rwanda's agreement with Israel. We have no doubt Rwanda gave its undertaking to Israel in good faith. I mean, we don't know, but they don't doubt it, and that the government of Israel believed that they would be fulfilled. The central issue is therefore not the good faith at the political level, but its practical ability to fulfill the assurances, at least in the short term, in the light of the deficiencies of the Rwandan asylum system, the past and continuing practices of reformer, and the scale of changes in procedures, understanding, and culture, by which they mean the culture of the legal system, which are required. And so the bottom line ultimately of this assessment of the court is to say um, we simply, on the basis of the fact, are not persuaded Rwanda is such a different place today when this judgment was rendered than when the agreement with Israel was signed, an agreement which ultimately Rwanda was not able to fulfill properly according to UNHCR. So there are a few lessons to kind of to draw out of this before I kind of I stop and then open it up for whatever questions and discussion people want to have. One lesson I think is that um, there is, as I've suggested earlier, no general bar for states to try and reach agreements with other states for processing of asylum seekers. And that is because the Refugee Convention does not mandate asylum processing to happen in the state, the first state the person had arrived. At the same time, there is no obligation, and this is often a misnomer in public discourse. There's no obligation on a refugee to try and seek asylum in the first place they've entered. It would be absurd, in fact, to ask to expect a Sudanese to try and seek asylum in Libya because there's no mechanism for them to try and seek asylum in Libya before trying to pass on. So the two things can be true at the same time. That there is no right to receive protection in your country of choosing, and that you do not have an obligation to try and seek asylum in the first place you enter. The two things are true. So if you make your way further beyond the first country into the second and third, the idea that you somehow stop being a refugee is absurd because, as we've discussed in the first seminar, refugee status is declaratory. You meet the definition because you have a well-founded fear of persecution. That well-founded fear of persecution doesn't change if you are now through your second or third or fifth country on your journey to protection. At the same time, once you have moved beyond the first country you've entered, if you are now in your second country of travel, if that country has an agreement to transfer you back, as you were, to the first country, and if that first country is one where there is a functioning asylum system, there is a good legal, independent legal system, there are protections for refugees once they're recognized, non-refoulement is being respected, other human rights treaties are being respected, then that transfer agreements may be legal under international refugee law, right? And those different complex truths can all and do all coexist in the sphere of refugee protection. And in fact, the idea that there can be transfer agreement is not in itself um, challenging the Refugee Convention because the Refugee Convention itself believed in responsibility sharing, even though it didn't create any mechanism for that to be the case. Where the cynical point has to come in, and this is where I'll end, is that it just happens to be the case that most of these agreements are agreements between rich, capable, um, well-resourced, well-maintained countries to transfer people to countries which, in some instances, already host a lot of refugees that are less capable financially or otherwise to do so. And the transfers seem to all be in that direction, and very few of them seem to be in the other direction. And so, from a general global justice or morality perspective, even if these agreements are not necessarily a breach of refugee law, they do raise certain concerns. They are uncomfortable. And as a result, I think many people find them distasteful. But there's a difference between distastefulness and unlawfulness, right? And the two don't always come together in relation to every agreement. So I will stop there. Questions, comments, challenges.
I just fear that in general, after like hearing the Supreme Court's ruling and after reading part of the cases, I think that we're facing a new chapter in the refugees I don't know, in the refugees reality, and I feel like that the international law has not adapted the new challenges and the changes that we are facing as human beings. Like there are so many wars all over, so many problems, and basically everyone can claim he has to be protected in certain way. That's my thought so far.
But so in what way do you think the adaptation the changes should occur? So are you claiming ultimately that the definition as it stands is too narrow, or is that it's too wide? That's the bit.
It's not okay. It's not about the definition. I think that the definition is okay. It's about like the operative countries can be in order to help people. I think that there are many kinds of refugees, and every group of refugees, depending on their history or the origin country, has to have a different approach. Um, so it's very difficult because we're living in a very dynamic world, and it depends. If a refugee from Africa comes to a country in Europe, it's not the same as if a refugee from South America or from Asia is coming to Europe. Like the culture shock is different, the reality and the protection they need is different from one person to another. So that's my claim. I think that in the operative way, international law hasn't been able to adapt as quickly as the changes of the world.
Right. So, okay, I mean, that's a very interesting claim. I think that's slightly different, right? So what you're saying is um, not so much what the grounds for protection should be. So you're saying the grounds of protection are that appear in the 51 Convention kind of makes sense. You're saying the ability of different states to give protection um, to specific individual may depend on the character of those individuals, the region they come from, their culture, that may affect their ability maybe to integrate, the ability of the state to offer them the sort of protection they need. And I mean, I think there are two types of responses to this. I think one is um, one of the aims of the Refugee Convention was not ultimately, whether it's successful or not is debatable, was not to allow states to say we're only going to accept refugees if they're culturally similar to us or from neighboring countries that have the same religion or the same ethnicity, uh, because actually the inclination of states is to do that anyway, right? So in a way, what we can learn, I think, from a case like Ukraine is that when there is cultural similarity, when there is proximity, when there is an assumption of a shared language and history, then states, in a way, almost don't need to be required by law to do something. They end up doing it, right? So the Temporary Protection Directive was a political decision to activate. Once it's activated, it has legal consequences. But um, but they did it in relation to Ukraine because of those reasons. And it's also the case that states that the practice in the world is that most people end up in neighboring countries, right? So the example of an asylum seeker from an African country in Europe is still the exception rather than the rule, right? It's still that more asylum seekers from Africa end up getting asylum elsewhere in Africa, right, in Uganda, in Kenya, and Rwanda, etc., than they are in the European Union in terms of numbers, right? And similarly in other regions, simply because of all the reasons we've discussed earlier today, because it's very difficult to get to another continent legally if you come from a global north, a global south country. It's very difficult financially. It's very dangerous. It's very expensive, right? So that I think is the first response, right? That in a way, I think the political reality is exactly as you describe it, is that states find it much more comfortable to to have refugees if they come from culturally similar backgrounds or similar skill sets and that. Um, but that is also what normally happens, right? So actually, the second point I would make that relates to this is that it's a question of where you put your emphasis, right? What are you focusing on? Are you focusing on the minority of refugees that are that are managing to cross international borders in the way I've described and get to a very different region? And if you do, and is the right response, right? And I'm putting this as a question rather than as necessarily a counter to your point. Is the right response to assume that people can't integrate because they come from a different region or different culture, or does it just mean that states have to work harder, have to be purposive and can still make it work, right? I don't know, you've got examples of people who have arrived in the United States from Japan or China that in the past, right, when there were wars between the countries, and of Jews arriving from shtetls in Eastern Europe to the US or to Western Europe, right? Those were different cultural spaces. And Israel itself is an example of a blend of cultures and backgrounds. So the question of whether we're deterministic about this being uh, unlikely to work, right? Unworkable, or whether we try to make it work, right? I think is a debate. It's a policy debate even more than it is a law debate, right? But the two, of course, are linked. So, but it's not to say the point you make is not one that is very much in the discourse, right? And I think it reflects the reality. I think you're not wrong at all. Um, And yeah, or do you want to come back at this or that? Oh, yeah.
Yes, I agree. And still, I think that, like in many cases in the international law, there's like a gap between how things are written and
Mm.
how reality shows up.
Yeah, no, I think that's a fair general point about international law. I think um, here in a way, what I was trying to describe towards the end is that actually international law created a bit of an, or international refugee law created a bit of an incoherent framework, right? Because it sets out a right to not be pushed back at the same time as not creating a right to actually receive asylum in a specific state. It says you can't stop people from arriving, but neither are you required to provide them with the legal means of arriving. So international law found itself in this kind of space that is a compromise space of these different frameworks, um, partly because I think they didn't want to fully follow the logic of genuinely being committed to refugee protection because of the effect that has on state sovereignty, on the ability to control who comes in, right, which is such a core principle that states want to maintain. And so there's a commitment to receive refugees, but at the same time, almost turning a blind eye in international law to all sorts of practices that are designed to limit the instances where you will actually have to accept refugees. So, and that's an ongoing tension, right? And part of my aim was to say, you know, to kind of to look reality in the eye, right? It's to say, this is the framework, right? It's an imperfect framework. Um, would we be better off? And I think we can even park that discussion maybe to the end of the course, but would we be better off with having no framework at all than having this incoherent, somewhat not always practical framework? My own view is that we wouldn't, that it's still a useful framework, albeit imperfect, but you might, I mean, this is ultimately each person, this course, etc's, determination. The end of this course, what do you think? Is the case. I'm trying to present the complex picture. Trying not to brush over the challenges. The challenges are real. So, other comments?
Thank you.
Cheers, of course. I think everybody must be also very exhausted because it's been a long session. So I think maybe we'll leave it there. We I think are reconvening at the same time tomorrow. I will, as usual, send the link. I'll also post the PowerPoint. And tomorrow we'll talk about exclusion and from refugee status, and then about the very much not controversial topic of Palestine refugees. I'm sure that will be that would prompt sufficient discussion to keep us awake tomorrow. So I shall see you tomorrow.
Thank you.
Thank you so much.
Cheers.
Thank